Close the window. It's 5 o'clock. You have to get on.
I'm texting you, Stacy.
Oh no, the other one.
I don't know, I just thought of these things, but in case you need them, I just sent you little bullet points. You don't have to say them, but.
Okay, can you send it to the 0661?
Oh, yes. What is it? 9-1? Oh, you know what? We're live, so I won't ask.
Okay, that's all right.
We'll start in just 1 minute. We're just letting everyone trickle in.
Okay.
All right. You want to take it away, Stacy?
Okay. Hi, everyone. We are excited to present our second educational series on copyrights and editorial contracts. We hope you come away from this webinar armed to make informed decisions on publishers' ever-changing contracts. Publications are granting usage to third-party brands. Photographers' work is being used in multiple titles worldwide with no additional payments. As the popularity of paid social and smart advertising grows, we see increased copyright infringements across social media. It is the agent and photographer's choice to agree or disagree with the terms of a contract. We hope to help you decide based on what is suitable for each talent you represent and come away with best practices in negotiating these agreements. The AMA is here to educate the photo community. Every day I reach out to my friends and colleagues with questions that I might have about our industry, but we all still maintain our competitive advantage by choosing what is right for our businesses and making that choice. Today, our goal is to help point out areas where you can ask questions and show where there might be flexibility to push back on terms if you so decide. Each contract has its own nuances and should be read carefully. The landscape is changing so quickly, and we don't have to sign a publisher's agreement automatically. Bill and Emily will walk us through what to look for and the language that is always really confusing to me. Bill Hannigan is the founder of two premium licensing agencies, August and Otto. He was also a photographer's agent for more than a decade. Bill and I first met when we were called into Time Inc. to discuss their new contract. And our conversations have been going on since then. Emilie Pitts is an intellectual property attorney representing artists and organizations with a focus on advocacy, contract negotiations, and copyright protection. She started her career at Stewart Weitzman and then moved on to Conte Nast in the contract department before becoming a photo agent. Kelly Montaz is joining us today. She is the president of the AMA, and we'll let Bill and Emily take it from there. Thank you guys so much for joining us.
Thanks, Stacy.
Thank you, Stacy, for having us. And Kelly. So, as I said, thank you for having us. This is a really exciting thing to be a part of. We're talking today about two different parts of editorial contracts. We really got into the weeds of talking about this, and there's two main components that I think are really important when representing artists, and that's editorial contracts and how to negotiate them, as well as infringements thereafter and how to deal with third-party infringements of your artist's work. So today we're talking about part one. We're going to go through it with you in a little outline that Bill and I have created for you today. Here's the outline. We'll run through the history of contract evolution, talk about some strategic negotiation tactics that you can take on behalf of your artists, run through the different types of editorial agreements that you may come across and the nuances within them. And then the bulk of this will go through individual sections of standard editorial agreement. We can open that part up for questions if you have any questions on a particular section, and we'll really do a deep dive on how to amend those clauses.
We're going to try to strike a balance between the legal and the business side, with Emily focusing on legal details, and I'll try to chime in on my experience to date with all the different business aspects that are involved in these different segments. Just a short kind of overview on the evolution of contracts. So in an industry that's not even 100 years old, there's been kind of two main phases of this balance or trade-off between photographers and publishers through this whole time. The first structure was basically that photographers became staff members. And this went on for a number of decades. And some of the biggest names in photography, Irving Penn, Louise Dahl-Wolfe, and others, were staff members of major publishers for the bulk of their careers. And then in 1976, due to some copyright law changes and some other business practices changes, things started to shift. And in essence, there was a fundamental shift away from the staff model, where the publishers own the copyright, to a complete freelance model, where the photographers then became the sole copyright holder of the work, granting the right of first publication back to the publisher. Trade-off on that was the photographers no longer had the guarantees of an ongoing salary, stability, benefits and all of these things, but they own their work. And generally, they were then paid for every additional use of their work as the copyright holder. We can go to the next one. And this has basically been in effect for decades, since probably the early 80s, and worked fairly well, particularly from an artist perspective, but I think it was a general balance, and worked until about 15 years ago when things really started to shift again. And there were a number of reasons for this. The first and probably most significant was the evolution and presence of online digital media. But very soon thereafter came the recession of 2008. That both of those two things combined greatly impacted the print industry and publishers. Those two things combined led to them look at the structure and try to gain more rights within their photographer agreements. And then beyond that, so we look at where things are heading today, we really have an imbalance, because as publishers have been struggled to make a proper business out of the traditional print model, they have looked to add other entities, other platforms, television, you name it, under their brands as a way to generate revenue and spread their content for an ad-based or subscription-based revenue stream. In doing so, they've looked at the content as a whole, and particularly photography, and said they need much broader rights. In that wish for much broader rights, though, there's not exactly been that maintenance or maintaining of that equilibrium and balance. So we're kind of in a tough phase right now, I'd say.
So here we'll switch into a strategy for negotiation. Of course, it's really important to share. You're all the agents, you know what's best for your artist. These are just suggestions along the way, just to indicate to you that, you know, changes can be made. Negotiations are usually always on the table, and whatever works best for your artist is what you should do, of course. But here we can touch upon a few different strategies that you can take while undergoing those talks. So, right. So the goal in negotiating any contract, of course, is to strike a fair and equitable balance. Also very important here to know that oftentimes a lot of people think of a negotiation as one side versus the other, and it can turn out to be that way. But I think it's really important to have the mentality that, you know, we're a partnership. This is a close-knit industry, and we should be working with the publications in order to reach a fair and equitable agreement for both parties. I think for the most part, there's a lot of flexibility for them to be understanding to reach an agreement based on your needs for your artist, and how you go into it matters. And there's different ways to go about doing this, so it doesn't need to be an us versus them mentality. Also, you know, important to lean into others for support, such as the AMA. Look to other people for knowledge, agents, syndication agents, for really where you can push back on certain parts of an agreement.
Yeah, I would just add that it really should be a dialogue. And, you know, if you can get someone from the publisher, whether it be the editor or someone in the contracts department, on the phone to have a conversation, to develop a relationship, it goes a long way. You basically have to have a give and take of what are their needs, what are your needs. And, you know, if you can talk about that in a real practical manner, you can probably come to a pretty quick solution.
There's different strategies for different kinds of work. And I come across this a lot because sometimes a corporate entity that has many different brands and magazines under their name may just send a template form agreement. The first thing to think about is whether the magazine commissioned your artist to do the work, or if they're using already shot images to publish within the magazine. Those agreements can and should look very, very different. Typically speaking, the main difference is exclusivity between the two. If you shot something for yourself and the magazine would like to run it, it's typically non-exclusive because it's either been public already or because you should retain the right for your artist to share it with others. And if they do want exclusivity over it, then there can be fees involved, etc.
Yeah, and I will mention,
yeah,
a little self-serving, but it's true. If your artists do work with a syndication agency, existing work, it should go to them, and those agreements should go to them. And really, the syndication agencies should dictate the terms of the license.
There's also some differences, of course, with the agreement, as you all, I'm sure, know. But the agreement itself may look the same, but the different terms should be considered when your artist is either shooting a cover or an inside story. You typically have more flexibility over your own syndication rights to the work, and sometimes ownership to the work if it is an inside story than it is with a cover. But often publications will own the cover as long as it has cover lines. There's also a lot of syndication restrictions that Bill can speak to later on that may be involved with the cover. So always things to be mindful where you can kind of push and pull a little bit, depending on what kind of story you're delivering for the publication.
You know, one thing I'll mention on the cover image, so I don't forget later, is a lot of contracts will read very restrictive for a cover shoot. And oftentimes you can change that to be the cover image and the cover within context instead of the entire shoot.
Mm-hmm. Another part is master agreements. This is becoming more and more standard, part of what Bill touched upon before in contract evolution, especially now with publications existing with many different magazines under one company, such as Condé Nast or Hearst. we see something that looks like more of a master agreement that's either tied to the entire company or to the individual magazine. And that allows for your photographer to shoot without signing an agreement each time and possibly just a schedule. So in order to, before you agree to any kind of, sweeping terms for every single shoot moving forward, it's important to really get them into a good place. And if you find that whatever decisions you would like to make for your artist, and if you find that, an editorial for them in a particular magazine is more important than owning the images, then that's your prerogative as an agent, of course. And then you can have more flexibility by turning it into a one-time project-based agreement instead of a master agreement. A lot of times publications will allow for this. That way you're not setting a precedent for any future shoots where you may have a bit more flexibility.
Yeah, and Emily mentioned you also will be issued many times even under a master agreement, a shoot schedule, which is a one-time assignment, terms and conditions, if you will. And oftentimes, if there's something unique to that shoot and terms you want changed, you can negotiate it there, and it will govern that shoot over the master agreement. It's actually a really good opportunity to change some terms at that level, at the shoot level.
Definitely. It's a great way to be a bit more, have the magazine agree also to certain things that they may not otherwise agree to in a master agreement. Additionally, it's often important to define what rights are not granted in the agreement versus the ones that are. We're always looking to kind of publications and brands to dictate to us as the artist what we are allowed to do. But ultimately, when it comes to these kinds of shoots, the goal is really to kind of shift that power back. And in order to do so, make sure that there's certain language that we'll cover later on that's important to add in, that all rights are, reserved to the artist if not expressly granted within the agreement. We'll touch upon more specifics to that as well. And another really good tool you can use is your terms and conditions. If you don't have one, I would suggest always, beefing up your terms and conditions as much as possible so you have an estimate in place. The terms are attached, and there's some sort of guidance in the event there's no agreement between the magazine and the artist before publication. So this is a good way to see what's included in the agreement and what's not.
Stacey, I think you're on mute.
Sorry, everyone. The AMA is actually working on terms and conditions that suggested that we are going to be posting shortly. So that would hopefully be helpful to everyone as well.
That's incredible. That would be a great asset. Here I just made this to highlight, of course, the different terms that not only we'll be talking about today and what I can speak about and Bill can speak about, but really different terms to look out for that we may not be discussing today that are still negotiable within your own business decision as the agent for the artist that you're representing, or if you're tuning in and you're the artist themselves, what you can negotiate on your part. So I kind of split it up between legal terms and quote agent terms. Really always important to include the shot count, things like this. That way the client or the editorial doesn't ask for an entire drive or all outtakes. This helps limit it. These are not things that an attorney would negotiate with the publication, of course, but just things to be mindful of. So the shot count, the fee, whether you will allow for modifications of the image or editing within by the publication, or if those need to be approved, who will cover the expenses, production costs, and when crediting your artist, if the magazine is able to use their name and likeness with or without permission. Those are really not things that we're going to necessarily talk about today, but still terms to be mindful of when negotiating the contract. And these other ones, they're listed here, but we'll do a deep dive into them for you and kind of go through them one by one. Part of what Bill had brought up is important to, and that I discussed, important to always include language that, talks about what is not provided within the agreement as well as what is. And so kind of a catch-all, always important to kind of scan and look for this kind of language or add it in yourself, which is an easy thing to add in. Rights granted herein do not include third-party advertising, sub-licensing, or merchandising. Also, another catch-all agreement that I love personally is all rights not expressly granted in the agreement are hereby reserved to the artist.
Emily, can you speak just a little bit about third-party rights and just give a little bit of background of an example of that so that people understand what that means? Should you grant third-party rights?
Yeah, definitely. And, we'll do more of a deep dive into it soon, but a bit of I think it might be the next slide actually, but a bit of a background is, no, it's not, sorry.
It's okay.
But a bit of a background is third-party rights are when a publication uses your photographer's published image to share with brands or advertising agencies in order to promote the magazine issue. So they may do that by giving them the files and asking them to share the image across different social media platforms. Or the brands, will do this, take it upon their own volition to do this. We'll talk a bit more about why that's not allowed and in effect, but it's per se copyright infringement, and that the kind of different remedies that are available to you as an artist, if you ever see your image being used by a brand that obtained it without permission or without proper permission. The best way to go about, licensing an image for a third party is if they see an image in an editorial that they really like, or that, a celebrity is wearing their brand, is to contact the syndication agency of the photographer or the photographer directly, because they're owners of the work. But of course, these third parties are not privy to these contracts. They might not know who owns the work. They may still be used to the old model where a photographer kind of owned everything. And they go to the magazine to ask for permission, and the magazine or the publication will give out these images. And that's an example of third-party use that may or may not be permitted depending on the terms within your agreement.
I think this is one of the most important clauses of the contracts these days. It's also probably the most convoluted and densely written. I find that many times, even within the publications, the people I talk to try to define and negotiate these clauses, struggle to understand them and define them. So we will get into it a little bit deeper, but it's definitely something to pay very keen attention to in the modern times.
Another example of third-party use that we come across a lot is if you're shooting for a said brand, and the brand is then also sold in a department store, and then all of a sudden, you see your images on Neiman Marcus's site, but you were just shooting it, you thought, for, a brand that is sold there. That would be third party, which is also not allowed, because really the only person that should have the usage, if they didn't specifically request third party, is the brand that you shot for originally.
Exactly, yeah. And these are all, and I'm sure everybody knows, but just to highlight, these are all examples throughout this. We'll be naming brands and different publications, but none of them are true examples. We're just using them as placeholders. That's to you, Neiman Marcus.
Yeah, sorry.
So here we'll talk about different types of editorial agreements. We'll breeze through this one and then get to the good stuff about talking about the different clauses that really matter and how you should be negotiating them. There are different types of editorial agreements. I'll let Bill speak to them because he has seen, I think, probably has seen them all many, many times.
Hard to mention. I mean, generally speaking, editorial contracts all have the same structure, which is what we're going to talk mainly about. So we'll go through this quickly. I mean, basically, if you want to go to the next slide, Kelly, there's, you can break them down this way loosely. The first two categories, fashion editorials and, general media publishing and celebrity, are pretty similar. There are some variations when you get into more journalistic publications. And the kind of key difference there is most journalistic publications will have very specific language around their right to syndicate. And we'll touch on that a little bit more in just a second. These are basically the same structure, like I was saying, but there's some key points here. Emily, I'll just touch on the last one because I was mentioning journalistic. A lot of them will want syndication rights, albeit exclusively or shared. So be mindful of that. Most will negotiate to at least a shared structure. And most, if not all, will compensate the photographer for their share of that revenue. You can also negotiate a cap on that syndication right, usually up to and including the embargo period. So be mindful of that, because generally speaking, any journalistic contract will have a clause in there that grants them some rights around syndication.
And by shared syndication, you mean, joint copyright ownership? Okay.
No, granting them usually states the copyright is retained by the photographer, but they hold a non-exclusive right to syndicate through third parties, and receive revenue for the syndication, and then it'll state the revenue split to the commission to the photographer.
And
you can also try to strike it entirely, which is what we try to do.
Right.
That's your prerogative.
And do you mind switching back to the previous slide quickly? Thank you. So there are a few different agreements as well that look a bit different between fashion editorials as well. Always to be mindful, of course, again, whatever is best for you and your artist, and whatever you feel is more important at that time for their career. You don't want to sacrifice an editorial over these terms unless you feel it's really necessary. But a lot of the times there is room for negotiation. And with the more corporate agreements that come from larger companies that own different publications, there's, as I mentioned, a master agreement, template agreements. But the other side of that is the benefit is that they come with legal departments oftentimes, and that provides an avenue for you to speak with somebody and negotiate a bit more. Whereas the independent magazines, similar to an ID magazine or Dazed or Purple or 10 Men or anything like that, there may be less room for negotiation, either because they don't have a legal team on staff, or a template was pulled maybe online, or they're using one that, it cannot really be negotiated. So sometimes always important, these contracts may be even more strict and oftentimes ask for the copyright of your image. So always be mindful of that. And that's all.
And I'll just make one more note on the celebrity component. The releases Emily wrote in there, they are legally binding, and they are between the subject and the photographer. They're not, the magazine or the publisher is not a party to those agreements. They also can be negotiated. They could be a separate webinar, but they can be negotiated. So discuss that, with your talent and between the agent and the subject's representatives as well.
So something to also say before we get into this is always good to have your version of an agreement. There is always the kind of situation where any magazine, whether it's very small or very large, may say, can you provide the agreement? It's either quicker that way, or it's easier that way, or we don't have one. And it's always very beneficial to kind of curate this for yourself, have one on hand that you can use as a guide to negotiate their own agreements. But if they don't have one, then you can provide one very quickly that, is much more fair and equitable. In so doing, we'll go through the different sections of an agreement that are very important to consider when looking at these publication agreements. The first most important one is work for hire. Traditionally speaking, for photographers at a certain level, once they start working a lot and becoming more in control of and choosing of what they want to do, this becomes less standard and you have a bit more leverage. But across commercial contracts and editorial contracts, you will always see brands and publications attempting to take the copyright of the image. This makes it easier for them to syndicate the image in the future, or just edit the image and kind of do whatever they want with it in order to promote the publication. Important to note that in California, they've eliminated work for hire, so actually not allowed. However, there's good lawyers everywhere, so there's ways around it, and they've created this loophole that this is the language of most California-based contracts that says the photographer hereby transfers and assigns the entire copyright over to the publication in any form, in any media, rather than it saying work for hire. But if it's a work for hire, that's what that means. It's a copyright transfer. So we've suggested some alternate language here. As between photographer and whatever publication you're working with, we'll refer to them generally as publication. The photographer owns the copyright in the works and hereby grants to publication a one-time editorial license to publish the selected works in print and or web versions of the magazine issue specifically stated. This allows you, that's the best version of that I think you could have, because it allows you to limit the use of the images towards a specific magazine issue. You still own the rights to the work. That puts you in control of syndication of the image in the future, and allows you to kind of hold control over the image. That way, if it's used by anybody else besides this one-time license, it has to go through you or your artist.
Yeah, as a pure business proposition, this is, for most of the photographers we work with, this is a complete non-starter to do work for hire, just because the upfront fee never justifies the grant of rights. So, they retain the right, want to retain the rights to the copyright for the life of the work, because that is a significant part of their business operations and revenue.
Another thing that sometimes, we try to do is, it more when someone's asking about a buyout, which is different than this, but I'm just going to interject. We like to say unlimited time, unlimited rights, if a client's pushing for that, and then still have the photographer hold their copyright.
That is the same often, actually. I think my understanding of a language of a buyout is typically a buyout of the rights. So that's another way that they can say, they'll own the copyright. So that's absolutely a good alternative to this. If it can't get in the best place, for one-time use, kind of a middle ground is what Stacey suggested, which is, giving the brand or the publication perpetual use, but still retaining ownership of it.
Yeah,
and we try to call that out on our contracts as well, that the photographer retains the right to self-promotion. So that's clear, because, correct me if I'm wrong, once they have a complete buyout of your copyright, technically you also then lose the right to self-promotion as well.
That's right. We have that in a slide coming up specifically, but yes, exactly. So you would become a user of the image just like anybody else, despite the fact that you took the image, you don't have a right to use it. It's very similar to, this language originates in, music law. It's a copyright law term, but it really comes from music, because it's very often for albums to own the music of an artist, and that's how they do it. They do it through work for hire. And then you'll hear about things like Taylor Swift not owning the rights to her own songs, and that's really where that comes from. So it's the same thing for imagery, exactly.
And if you are trying to strike a compromise like Stacey described, that is a place where you want to define what rights are retained very clearly.
I'll leave this one to you, Bill.
So basically, embargo is very essential, especially from my perspective as a syndication and licensing agency. But for all artists, I mean, this really defines kind of the lifespan of a work in many ways, because publishers are pushing for greater, longer embargoes all the time. The longer those embargoes are granted, the harder it is for the photographer to capitalize on their work immediately. Generally speaking, there is, time is of the essence. Most of the work being created is, for a contemporary moment, a project, a film release, an album release, something that's happening within the cultural world. So you need to try to, have available to you the ability to license that work and capitalize on it as quickly as possible. So generally speaking, the embargo period will be directly tied to the exclusive first worldwide right to publish. It can vary. Industry standard has been for a very long time, 90 days. International embargoes will stretch much longer. But you really want to try to lessen that as much as possible. Generally speaking, it's an area publishers will negotiate, so you should always ask and push on it. You also, which Emily put in here, you don't want to give over control of unpublished works for any great length of time. And basically, within the embargo and the description of international rights, you also want to define embargo within that. And once that edition does publish the work, again, so if it, as an example, if international editions have 1 year to option and publish a work, and they do publish it, you want to reduce the embargo in that market down to 90 days from first publication, things like that. And those terms are generally not in standard contracts. So this is an area you really need to pay attention to and kind of maneuver a little bit. And then Emily's added kind of an amended recommended type language at the bottom here, if you want to speak to that, Emily.
Sure. I mean, it's different for, the kind of artist that you're working with. A lot of this kind of term will be tied into the exposure that your artist already has inherently. So, and that kind of lends itself to whether the publication will be more flexible on these terms. So it's really, really up to you as the agent to determine what's best and more standard, always kind of looking to previous agreements at what they've agreed to. And little ways that you can, gain a little bit more control over the image, and where it ends up is, like Bill said, lessening the amount of time of exclusivity that the publication has, but also adding language. Like here I underlined, okay, they have 6 months exclusivity to the cover, but it's with cover lines. So then the underlying image itself would lend itself to the, prior time frame of exclusivity, which gives you more time to be able to syndicate the image. That's unlikely, but these are ways to add a bit more control over use of the image. Oh, and more importantly, that's where I added Kelly's point that the term that will probably be on my gravestone one day is, nothing herein will prevent artist or his representatives from using the work for self-promotional purposes. I think I've probably typed that sentence more than any other in my life. It's really, really important in order for, no matter what, even if your artist owns the work, but especially if you're here and you're watching and you represent videographers or DPs who aren't really able to own the work because that falls to either the brand or the director, then this is a way that you're still able to integrate the work into your artist portfolio. Always make sure there's self-promotional language in there. Almost everybody will agree to it at this point, but sometimes it's overlooked and it's implied, but it's good to have it in there.
Yeah, then one thing as well with the last slide and this one as well, there's around promotional rights and third-party rights. This, again, as we mentioned earlier, is an area of really keen concern right now, and again, very nebulous language within contracts. The issue we run up against a lot right now is how broad and sweeping those publicity rights granted and third-party rights can be, or just the general vagueness of the language in the contracts, and then how it's interpreted by publishers. Stacy was also describing, then the publishers are requested for use of the images, and they're very broadly distributed. Sometimes it's through the internal publicity department at the publisher or the title. Oftentimes they're also hiring third-party PR companies, and in their mind, the more people that have the images, the more clicks, the better it is. They're doing their job. Unfortunately, that runs pretty much afoul with the photographer's rights to the images and what they want to see with the images. And so you want to also try to encourage the publishers to have very defined language about how the images can be used when they're distributed. And it would kind of shock you the limit or lack of language when publishers send out the work. I've seen many, many times with the link to the high-res images with absolutely no terms to define how they're used for PR rights. So, if you can have specific language that says it can only be used during the embargo or during the on-stand dates to promote the magazine, only in contacts with a link back to the site, of the original publication and a photographer full credit, that's ideal. Or else you can lead to the situation like we have on the next page.
Important to know, right.
Emily, sorry, 1 second. And the other people that are sending out the images a lot are the fashion departments. And they're actually sending them to all the brands, encouraging them to use them. And by doing that, not only is it breaking the copyright for the photographer, it's having the photographer break the embargo to the magazine. So their own fashion departments are making that happen. And I know Emily's come up with this before, and the publishers aren't even talking to the fashion department, and they don't even realize what's happening, right? Is that correct?
Yeah, exactly. I mean, I think that, like, in very simple terms, what's happening, and this is why it's so important to go back to kind of how we led into this, to really can think of this as a partnership with the publications, because this is a point for them that is extremely sensitive. Of course, their job is to promote the magazine. And when, you know, your artist, your photographer is shooting, and I'm just saying Jennifer Lopez because she's on the screen and because she's really hot in the news right now. If they shot Jennifer Lopez and, you know, they'd like to promote that story, it's in order to do it through third-party brands, they need to ask for permission from the owner, because anytime that image is then posted on Instagram or on their website, it's a use in commerce. That's my, you know, legal controversial opinion, but I think it's a use in commerce, because an Instagram page is really a branded outlet for these third parties these days. And it's really the main way that people look to see where a brand is. You can shop directly on their website through an Instagram page. So anytime these images are lifted, posted on their Instagram, even if it's not click to buy, but especially if it's click to buy, they need permission in order to do that. That's what syndication agencies are for. That's what photo agents are for. That's, you know, the job is to provide an avenue for them to be able to use it. But the other important component of this is, if you are shooting a celebrity, there's that release that Bill was talking about before that you're also a party to. And almost always, in my experience, the language will say, will come with some restrictions for how that use of that image can go forward. And often it will say that the photographer is responsible to make sure that the image is not used commercially. And if it is used commercially, that they will get the permission from the talent directly. The magazine is not a party to these releases. Photographers are. I'm sure you're all very familiar with that. So it presents an issue if then the magazine steps in to give it to a third party, because it also violates, you know, the photographer's responsibility to the talent. So that's where this language that can, you know, look super broad and just say the magazine has the right to ancillary promotion, they can use this as a way to distribute these images without permission. So that's kind of why we felt this was an important thing to touch upon, but also to highlight to the magazines, you know, there's a way that we can all do it together transparently, and, you know, at the very least notify the photographer of those third-party requests to promote the issue.
And this is an example, which is fairly commonplace, to be honest. The original commissioning magazine is Billboard. Photographer we worked with did this session. The Daily Mail, in this case, asked permission to publish the story. They were given permission. There is a clickback buried in all of this, but I was given a copy of the actual distribution email. There are no restrictions put on the images, and the direct link to all the high-res imagery. What they've done here is they have a section where they put the actual dress, as you can see here, up for sale. It's a straight click through to buy, with revenue going back to the Daily Mail if you purchase. It's also driving all kinds of traffic for the Daily Mail and not really for Billboard, because the link back was buried 3 pages down. They also do this very often with a kind of fast fashion knockoffs. So just as Emily was describing, not only does this kind of run afoul of the photographer's rights, but also you know, J-Lo in this case gave no permission for her to endorse this brand or be basically a public commercial spokesperson for this dress. So could totally run afoul of the celebrity rights as well. And in showing this back to Billboard, they were, you know, they were blown away by this. They had no idea that this was happening, that it occurs, and it occurs frequently. So it's not of their interest as well. So to the bigger point of what Emily was saying, that, you know, you have to be looking at all this in a partnership. This didn't work for anybody. And the reason it didn't work is because nothing was defined. It wasn't defined properly in the contract, and it certainly wasn't defined in the distribution of the work.
We're passionate about that one.
Because it's becoming a scourge, a plague.
Yeah. Here, important to kind of, we can go through this one quickly, but sometimes the magazines will be big enough to have international editions. Really important. Bill will let you speak to that because you're more familiar with kind of how those fees look and if the fees exist at all for that.
Yeah, I mean, more and more publishers are moving to a one-time fee to try to have all their internationals editions use it for that same fee. That fee is not going up relative to what a industry standard one-time use fee would be. There are some publishers who will offer a percentage of the commissioning fee. So all the other international editions can use it for 25, 50% of the original fee, which again is a paltry sum. And there are some that will pay per use and even pay per size of use, whether it's a cover, full page, quarter page, etc. But those are actually retracting. So more and more publishers are asking for all rights to all international editions with no additional fee. And this is, again, you know, something that is kind of moving in the wrong direction. So trying to cap the amount of time that an international edition can option to publish it, cap the amount of time that if they don't publish it, the rights revert back to the photographer, cap the amount of time if they do publish it where the embargo is extended in that market, etc. Again, trying to work this particular area of a contract to a more fair and equitable structure. I mean, ideally, Emily's added language at the bottom that would be the ideal scenario and used to be industry standard. If you can, you know, nudge people in that direction, it's beneficial for all involved, all artists involved.
This is an easy one. Typically, there will always be an agreement language. Sometimes it's in its own section, and sometimes it's just buried in there. And you just want to look to make sure that, especially if it's an editorial, you know, it's not well, also for commercial projects, that the party responsible for releases for the talent or the property or the music used in any kind of video is done by the publication. Often if your artist is shooting a celebrity, then the celebrity will have their own PR team that provides the release, and that's fine. But if your photographer is doing a test shoot with models or even a published shoot or a commissioned shoot with models, good for you to always have your template of a release in place so you can always use it, which allows for the photographer to use the image freely thereafter. But here the language, it's just a note to, try and shift that obligation from the photographer onto the brand or to the publication to be the one responsible for getting property releases, talent releases, etc.
So kill fees are pretty standard in all publications. For me, this structure, so this used to basically be if the shoot was not published, it was killed for some reason, the photographer would still receive their compensation. Definitely all expenses are paid. This has shifted over the past few years as well, moving even towards a 25% of the original fee will be paid. I like to negotiate this to only be any kind of reduction if the photographer did not perform their duties, and that can be clearly illustrated. So if the photographer showed up, did their job, did it properly, and for some other reason the magazine or the subject determines that the images are not going to be published, the photographer should receive full compensation. They did their job. So I always try to negotiate to 100% for that. Also, sometimes there will be language that if they decide not to use it in the commissioning title, they can reassign that within the group or the entire publishing group. So a sister title or the entire publishing group. We try to limit that only with the permission of the photographer. And also to cap the amount of time where they can exercise their decision to publish or not. Generally no more than a year. If no one is published under the publishing house within 12 months, full rights revert back to the photographer.
I'll leave that one to you too.
I was going to leave this one to you.
Oh, okay. I'll take it.
All right.
So pretty standard for publication rights to say that they have the non-exclusive right to publish, republish, reprint, reuse. Sometimes it says create derivative works of. Always really good to remove that. That means they can take your image and put it on a keychain and sell the keychain. And you really don't want them to be able to do that without your permission. In these kinds of clauses, there's sometimes a lot less room to negotiate. So the thing if you're coming up against a backstop in your negotiations, what you can do is always provide at least, if you can't get approval for the publications, for the right for future use of your image by the publication, then what you can do is get notification. And at least they have to notify you. Here it says photographer further grants to publication the unrestricted royalty-free right for the full term of copyright to syndicate the works to third parties around the world and retain the proceeds. There's a lot of room for movement there. It would be great if this was an option period instead of the right to syndicate the work forever. Of course, these are very broad terms to look out for related to the third party use we spoke about before and syndication of the image moving forward.
Yeah, this is another clause, I think, where it's very important to try to define what it does not cover.
Right. So what you can say, and the ABC here that I've included in the amended language, are different options of what you can say as you negotiate. You know, if the publication exercises the option to syndicate the image, you will receive to either one of their, their own publications or to a third party, then you will receive a shared fee with them, a one-time flat fee, a fee per image, or sometimes it's a fee per page or half page in a magazine. These are ways to not only get paid for the future use of the work, which is always great, but keep track of it and really be notified of it. This is a big one for us that we've already spoken about, but really important to kind of be mindful of the third-party licensing language. The promotional language we talked about before ties into this as well. There'll usually be an additional term for third-party licensing that says for no additional consideration, which means payment, they'll be able to distribute the image or video and in print or not and non-print. And if you're being approached by a magazine to shoot a digital editorial and they say this is the only thing it's going to be used for, but then you get an agreement and it says print, distribution, reuse, the best thing you can do as an agent or as the artist yourself is to just match this particular clause to the usage you've been given. And then you'll see what they really wanted to do with the image. They're not our enemy, of course. We work with them all the time, but this is where you can clarify the usage because it talks about really the usage of the image after it's published initially, which you've already approved.
Generally mean this to be for distribution on other platforms, Apple News, etc., and for PR, but it's usually written very broad and misleading. So as Emily's saying, if you have alternate language or things that define the actual usage, try to put in that clarification here and specific clarification on the rights being granted again.
This provides a backstop. If your artist shot Jennifer Lopez for Versace and then Versace used that image, or I'm sorry, they shot Jennifer Lopez for a magazine and she was wearing Versace, and then Versace, uses that image on any one of their platforms without permission. This is exactly what we were talking about, how to kind of prevent that from happening. So you can say something like, notwithstanding the foregoing, very legal, during the embargo period and thereafter, publication agrees not to license or distribute any published or unpublished works to any third parties without permission. That without permission part, allows them to still do it as long as they ask for permission. So it gives the magazine more flexibility, and it's a relationship you're building. So you don't want it to be too strict, but this allows, the conversation to continue between you, your artist, and the magazine when there are future requests to use the image. I see these more and more. I'm not sure if they have always been in the agreements, but ever since I've been familiar with them, I've seen, non-competes of all different kinds. Always good for you to, be mindful. If there's a celebrity that's doing a big movie promotion, you don't want to be prevented from shooting them across multiple publications. And sometimes this will say something as broad as the photographer will not create, participate in, or publish any images or videos of the very same person or in the same place in a similar setup. So I have here, always look out for broad language saying anytime, anywhere around the world, which, is always, you should always be mindful of this. And then use of the word similar instead of same. Similar makes it more broad. A way to limit this is to change it to same. You can't do the very, very same thing for a competing magazine, of course, but you can do something similar if it's after a certain time period. These are ways that you can change it to make it more flexible for your artist.
Yeah, we generally, these are becoming more commonplace, I've found, and we generally try to strike them completely. Most artists of a certain stature, that happens pretty quickly. But if it doesn't happen, one of the other compromises we try to do is, limit the non-compete to a very short amount of time of the same subject for a direct competitor only.
We're almost done. Always at the bottom of every agreement, you'll see indemnification, and you might not know what it means, but basically, in very simple terms, indemnification is and holding harmless is a covenant, an agreement with both parties of the agreement not to sue each other if there's some sort of third party claim that happens as a result of the agreement or as a result of the images being taken or shared by third parties. So if a third party were to sue, the magazine can't counter sue the photographer because the magazine and the photographer are part of this agreement. So important not to strike this, always good to have it, but make sure that it's mutual, because 90% of the time this will not be mutual. This will say the photographer indemnifies and holds harmless publication, because indemnification doesn't just mean that you won't sue, it means that you'll also pay the damages. It's not very equitable to assume that a photographer will pay for a publication's liability. So one option is just, and what I have here in the amended language is to remove indemnify completely and keep hold harmless, which just means you agree not to sue them instead of pay for their legal fees, and always say both parties. So both parties will agree not to sue each other and indemnify each other if need be. And I just added this in because more and more our photographers are signing a assumption of the risk waivers in order to be on set, and they're just doing it, and it's another way that magazines or publications can shift liability. So although we do need to be aware of the fact that we're all in a pandemic and there are risks that we're undertaking willingly during a pandemic to shoot and to work, there are still things that can be negotiated within them. And it's just a matter of kind of thinking about who really is responsible for something. And if a production company is putting on a shoot for a magazine, really who is the party that should be making sure that people have masks and PPE and sanitizer. And often that's the production company, but these waivers, sometimes say the photographer is responsible. So just look for that, opportunities to kind of shift liability there. Also, what to do if the shoot is canceled because of COVID, if there are payment penalties, or because one person on set tested positive, what are you going to do? Is your photographer still going to get a fee? Are they going to get a half fee? These are places that you can include that kind of language that would normally be in a force majeure provision in the agreement. So here I've added some sample language, and you can refer to this because these terms are very standard. So we'll talk a little bit more about an overview of everything we just talked about. Those are all the individual sections. If you want to click on to the next slide. Yeah, we have here always, as I mentioned, always have versions of your own agreements on standby to use in the event a magazine or publication doesn't have one. Look for opportunities to implement changes to a master agreement on a per assignment basis. So if there are terms that you don't feel are super favorable to your artist, but you'd like for them to do the shoot, you can say, okay, we'll agree to it one time. I don't want this to be a master agreement. And that gives you some flexibility. Use your terms and conditions as a guide when negotiating these agreements. The agreements will often say, this agreement controls over any terms and conditions signed. So even if you have a signed estimate, the agreement will control. So it's good to kind of fit as much of your terms into those agreements as possible. Bill?
Yeah, I think this is a big point. I mean, as we're doing this through this webinar and through the AMA, there's a lot of industry knowledge out there. Just lean on people, ask other photographers, agents, anybody, your syndication agent, whomever, to, for guidance if there's something you don't understand, or reach out for legal advice. There's a lot of knowledge out there, and if we start to ask the same questions of the same publishers, things will shift.
And something always to leave you with is to always register your photographer's images, or if you're a photographer, to register them yourself. You have 90 days to register from the shoot date before it's put into a tangible medium, which is usually the shoot date, in order for it to be timely registered. The timely registration aspect we'll get into in our next portion. We'll talk more about the importance of registration when defending an infringement. You're always able to collect damages on any kinds of infringements that occur, but really have more standing if it's a timely registered image, because then you avail yourself to statutory damages as part of the US Copyright Act. So there's a lot that we're going to talk about next time that kind of builds upon this. Ultimately, of course, it's up to you and your artist for whatever works best for you. But it's for you to know that you have options to negotiate. And the more that we negotiate together, and the more that we are on the same page about what's available, then I think the more amenable, the publications will be. Thank you.
Kelly, do we have time for some questions and answers, or do we have to wrap it up?
You know what, there's still some attendees on, so why don't we just take a few minutes to go through some of the questions, and I think that somebody also had their hand raised too. Are you able to see the chat box?
I see a question from Jennifer.
Yeah.
So Jennifer's asking, back to the broader contract with large publication companies that also have specific assignment contracts, do the terms for the assignment contract overwrite the broader contract for the licensing? For example, if the broader contract gives broad rights, but the assignment contract restricts the license of the images, which applies if there is an issue down the line. Bill spoke to that a little bit, so he can answer.
Yeah, you have to define that in the assignment sheet. So you have to make sure it clearly states that those terms override any other terms in the master agreement. If it doesn't say that, then they won't, but that is your opportunity to state that.
Stacey, are you able to see Sybil's question in the chat. That's more of a comment.
Yeah, it was more of a comment. Sybil just said that also trying to reduce the optioning period for international editions, 30 days from first publication to book the story and 90 to 180 days to actually use. Request to use the story after optioning period will be at market rates. And I think we addressed that. And just so everyone knows, we will be sharing the slideshow document that Emily and Bill put together so everyone could refer back. I know it was a lot of information for everybody to take in. And we also just want to clarify that the webinar is to give you tools for negotiation. What you guys agreed to is ultimately your choice. We just wanted to help with clarifying language and helping everyone wade through this, which I know is quite complicated and it's ever changing. So I think we might have another questions. Jamie Applebaum is asking, do places like Facebook and Instagram fall under the same kind of editorial rights?
It depends. I think if you're shooting for Facebook and Instagram, like as a client, I assume that's not what you mean, but so no, of course that would be a commercial agreement. But if the images are shared on Facebook and Instagram through a publications in a Facebook or Instagram, it's technically editorial. It basically doesn't become editorial on Facebook, or it's no longer editorial when it's used by a brand that sells products. If it's click to buy, if there's any kind of shoppable link on a website, that makes it commercial use. So it's not an editorial. I hope that answers the question.
I think Jamie added Facebook is the client.
Oh, then no, it's not an editorial. I mean, not necessarily. It could be. It depends on.
Sorry, just to clarify, I think what gets really confusing is now we get a ton of requests from brands saying that they want one of our photographers to shoot their editorial. Right. What the brand means by that is that they want it to not look like an ad campaign. They want it to look like it's looser or more creative, like an editorial. And I think that gets really confusing for people because you think, oh, it's editorial, limited use, or, you know, how we're used to hearing that. But it is still for a brand, and that is commercial use, but they just want it to seem like it's more organic and that it's not a commercial. I hope that answers the question.
Yeah, that way. And if it's for Facebook, it may still be an editorial. I think it depends on what the usage is there.
Are there any more questions?
Correct. Editorial style, not editorial use. Yes. They'll try and get away with editorial rates because of the style too, but not the case.
Okay. I guess if there's no more questions, we're going to wrap it up. So we will email everyone and let you know when part 2 is going to happen. Thank you so much for joining us today. And we hope that it was helpful. And the AMA is open to any feedback from you guys on what other subjects you'd like us to cover. And yeah, we're just so happy to be here with you and to have the honor to share this content and, you know, have a community where we can all be together and speak to the issues that we're all having. And thank you, Emily and Bill, for joining us today.
Thank you. Thank you, Emily, Stacy, Kelly, and the whole AMA. Thanks a lot.
Thank you, everyone, for